One pre-need application can spare your family an eligibility search during the week of your loss. Professor Havel studies memorial benefit access, and she's at the desk to keep this promise inside its legal fence. Stay with us, because one ordinary storage choice determines whether that paper is useful years later.
That boundary matters. VA calls this a pre-need determination of eligibility for burial in a VA National Cemetery. It answers eligibility before the time of need. It doesn't make the later arrangements.
My guess was that pre-need meant picking the cemetery and plot now. Professor Havel, where does that fall apart?
At the word preference. An applicant may name a preferred VA National Cemetery, but the determination doesn't guarantee that cemetery or a particular gravesite. Availability and scheduling still belong to the later arrangement.
So the myth is tidy and wrong. Approved doesn't mean reserved. History's verdict on confusing a determination with a deed is brief. It ages badly.
The straight version is eligibility now, arrangements later. Arlington uses its own process, not this VA National Cemetery application. And a funeral home plan is another choice again.
That's a smaller promise than I assumed, but perhaps a more useful one. It removes the eligibility threshold from a grieving household's list without pretending to make every choice.
An eligibility result lets survivors approach scheduling with the agency file already in VA's system. It can't make space appear at one requested cemetery, and it doesn't choose funeral home services, clergy, transportation, or a private provider.
4 different jobs, one dangerously vague phrase. We have run that filing experiment before.
Lewis, the useful historical habit is the paper trail. Tell the household the approval exists, store it beside the discharge paper, write down the cemetery preference, and name the future caller.
Wait, if VA keeps its own copy, why should the household keep one too? Am I close if I call the local copy a map and VA's copy the official file?
Very close. The local copy identifies the eligibility answer, applicant, and wishes the group discussed. VA's retained application and supporting documents help the agency confirm the case. The household packet helps a real caller reach the right office with the right name.
A parent and adult child shouldn't have to reconstruct this conversation later. Put the approval where both know to look, then say the location aloud once.
That separates the agency file from the household handoff, but the opening storage promise stays open until we build the future caller's complete packet. Next comes the harder issue, whose eligibility this process can determine.
So approval settles one threshold early, but the applicant category decides which eligibility path VA is evaluating.
Keep that distinction. Decide eligibility early and arrange burial later. Coming up, the status VA is actually evaluating. Real quick, because this next part matters to you. If any of this is helping, tap that like button, then hit subscribe and ring the bell so the next one finds you. Both are free and take about a second, but they tell the algorithm to show this to one more person who needs it.
My first pass is too broad. Every veteran and every immediate relative qualifies. I can hear the exceptions arriving before I've finished the sentence.
Start with the veteran, Liam. VA's public rule says a veteran who didn't receive a dishonorable discharge may qualify. Other than honorable and other character of service cases can require VA to determine the evidence.
Service category matters too. Active duty, certain reserve service, and training histories aren't interchangeable, so a slogan can't decide a case.
So I should ask this as a chain, not a label. Qualifying military history first, discharge boundary second, legal category third, and any individual bar last. Am I close?
Close, with one adjustment. A spouse or surviving spouse can have derivative eligibility tied to the eligible sponsor. Minor children may qualify, and some unmarried adult dependent children qualify under narrower disability and dependency rules.
Let me try a cell phone plan map. The sponsor's military history is the account, the legal category is the authorized line, and an exclusion is the rule that blocks activation. That keeps the categories separate.
Then what happens when a former spouse leaves that plan? One catch. Unlike a phone account, nobody privately adds an eligible line. Federal eligibility rules define the legal connection. The applicant doesn't customize them.
Literal version, VA evaluates the individual's service or qualifying dependent status under the burial eligibility rules. The phone map helps sort the issues, but it doesn't create eligibility.
The tree is useful if it refuses to pretend every branch is simple.
So anyone who was once married to the eligible veteran keeps that former spouse path forever.
No, Liam, the ended marriage matters. If the marriage ended by divorce or annulment, a former spouse doesn't qualify through that ended marriage unless independently eligible as a veteran.
But remarriage after a veteran's death doesn't automatically erase a surviving spouse's eligibility. Similar words, different legal categories. That's why the application asks for documentation instead of accepting a kinship label.
I was about to merge former spouse and remarried surviving spouse. That would have been spectacularly unhelpful. My notebook is literally titled 1000 questions, and this correction becomes entry 342.
The marker says veteran. The eligibility file says much more.
One more boundary. This episode can't decide an individual character of service case or dependent adult child case. Those are document issues for VA, not a verdict from our checklist. That boundary leads to my useful test. Not do all relatives count, but which eligibility category and military history is VA evaluating?
Names on a pedigree aren't interchangeable with eligibility categories. Build the next conversation around identity, basis, and evidence. Professor Havel is back with us, so let me hand you the live issue. How do we state the sponsor rule without making every household sound identical?
Begin with the sponsor connection. The veteran or service member supplies the eligibility basis. The spouse, surviving spouse, minor child, or qualifying unmarried adult dependent child has a defined link to that basis.
My wrong guess is that the veteran must be buried in the same national cemetery first.
No. VA says a spouse or dependent may qualify even if the eligible veteran isn't buried or memorialized in a national cemetery. The applicant's eligibility isn't a seating chart.
A cemetery rule with fewer seating chart assumptions. Progress.
There's another counterintuitive point. Eligible spouses and dependents may be buried even if they predecease the veteran. Don't assume the order alone cancels the eligibility path.
Finish that for me. If the spouse dies first, the veteran must abandon the plan.
No. Order alone doesn't cancel it. The issue remains whether the spouse or dependent meets the applicable eligibility rule. Sequence isn't a substitute for status, kinship, or documentation.
A dinner table is where to explain that, not a crisis call. The calendar shouldn't be allowed to invent a rule.
Keep the discussion specific. Who wants national cemetery burial? Who is the eligible sponsor? Which papers show marriage, age, disability, or dependency when those facts matter? Where all covered creates work later because it hides the individual behind a group label.
That changes my notebook entry from relatives eligible to 3 columns: identity, eligibility basis, documentation. A 4th column can hold the preferred cemetery without pretending preference is a guarantee.
Good. It prevents another harm too. Treating a dependent adult-child rule as though adulthood alone were enough. That branch can depend on disability, marital status, and support facts that need their own papers.
The table isn't paperwork for its own sake. It's the conversation the future caller shouldn't have to improvise while also choosing a funeral home and notifying relatives.
One more limit. Pre-need is a determination, not a permanent freeze of facts. If a marriage, dependency status, contact detail, or law changes, the later scheduling review may need current information.
So preserve the letter, but don't treat old supporting facts as untouchable. Update what VA tells you to update and keep the local packet current.
Before we get to the application route, keep that status warning. Current supporting facts matter. Now, where do those households actually apply?
On the issuer's page, not a funeral home advertisement.
The right page says exactly what this application is for: planning burial in a VA national cemetery before the time of need.
And if the individual has already died pre-need is too late?
Different door. The caller arranging the burial contacts the scheduling office and starts a time of need request.
Before death, VA provides 3 application routes: online, by mail, or by fax. The paper application is VA Form 40-10007. The current page directs mail to the National Cemetery Administration Evidence Intake Center in Janesville, Wisconsin, and owns the live fax instructions.
Then the online route must be the stronger eligibility claim.
Different route, same eligibility test. The page doesn't promise that one route earns a better answer. Online can be convenient. Mail or fax can fit someone who needs a paper packet or representative help. The frill page is clearer than the phrase "Contact VA." Online appears first, and the paper form sits under the mail or fax option.
A form that tells you which form. Bureaucracy occasionally labels the drawer.
The serious point after the dry one is to use the current VA page. Addresses, fax routing, and interfaces can change. A saved blog post isn't the operating source, and an old printout shouldn't outrank the issuer's live instructions.
I also see the boundary between applying for eligibility and scheduling after death. Similar burial topic, different action.
Exactly. The separate scheduling page is honest evidence that there are two workflows. It can't stand in for the pre-need application, and a creator's commentary isn't our authority. VA's page is.
Nor does this VA form govern Arlington. That exception belongs on the first page of the household notes, not the last. Separate cemetery system, separate application path.
An older couple can choose online or paper without pretending the route changes the eligibility rule. The practical test is whether they can finish it, save the submission confirmation, and answer a follow-up.
Save the confirmation. If VA asks for more information, answer through the agency's instructions. Starting the application isn't the same as giving VA enough support to decide it.
But if a representative helps, the represented individual should still know what was submitted, which route carried it, and where the confirmation lives. Otherwise, help becomes another black box.
One last screen check makes the boundary visible. This watched excerpt shows the separate time of need scheduling page, not the pre-need application. Choose the route you can finish, preserve, and explain to the next caretaker.
My anxiety check, no DD-214, no application.
No, VA says that if you don't provide a DD-214, it will try to find the records needed to determine eligibility. Providing the separation record can still help the review move cleanly, but a missing copy isn't an automatic bar.
Missing isn't the same as optional forever, and VA's search isn't a promise that every old record will be effortless to locate.
Right. VA may locate service records, but a spouse, representative, or dependent child application can require different documentation, so the packet changes with the applicant instead of growing into one universal stack.
Build it in this order: identity and contact information, the sponsor's military history, the available separation paper, family status or dependency documents, and authority paperwork if someone applies for another individual. VA identifies Forms 2122 and 2122A for representative paths.
That order has a reason. VA first needs to know whose eligibility it's deciding, then which military papers support the request, then whether another legal status or representative changes the evidence. Then open the folder, not 6 email accounts.
I started to say every applicant needs every document.
No. Match proof to the application.
Match proof to the application. A veteran applying for themselves is not the same packet as a caregiver applying on behalf of someone who cannot sign.
And a dependent adult child isn't proved by writing dependent twice. The family status word points to the evidence. It doesn't replace it.
VA's page says missing supporting documents can be submitted after the application, but the agency can't process the application until it has all required support. So starting preserves momentum. Completing the file makes an answer possible.
The catch is that submitted can feel finished when it isn't. If IF asks for a document and the request sits unanswered, the calendar moves, but the evidence doesn't. The binders aren't the goal. A findable discharge paper, application confirmation, follow-up request, and later eligibility letter are the goal.
Label the folder in words the future caller will recognize. An archive that requires its own archaeologist has failed.
If the answer is unfavorable, read the explanation and the decision review options VA sends. Don't turn one pre-need denial into a permanent assumption, because the agency will make a new final determination at the time of need if circumstances or law change.
Professor Havel is back with us for the cost boundary, because one eligibility approval can't answer every invoice issue. The phrase burial at no cost needs discipline. So what is actually included?
VA lists a gravesite in a national cemetery with available space, opening and closing of the grave, perpetual care, a government headstone or marker, a burial flag, and a presidential memorial certificate at no cost to the household.
My leap is that the funeral home and cremation are therefore covered too.
Stop there. Those are separate costs. VA separates cemetery benefits from items and services bought from a funeral home or cremation provider. The scope word is cemetery. It doesn't silently expand to every private invoice.
Those provider expenses remain the household's responsibility, although a separate VA burial allowance may be available in some cases, so national cemetery eligibility isn't a universal invoice payment.
The word free has now been placed back inside its fence.
Both things are true. National cemetery benefits can be substantial, but pre-need eligibility doesn't price or purchase the rest of a funeral. I spend weekends restoring a 1950s card catalog cabinet, drawer by drawer, properly labeled. One drawer holds VA cemetery benefits, another holds private provider choices.
The wide view helps. The cemetery is real space with availability, operations, and memorial standards. It is not an abstract voucher.
Cremated remains can be buried or inurned in national cemeteries with the same respect as casketed remains. The disposition choice doesn't turn the cemetery benefit into a lesser memorial category.
That also separates eligibility from preference. Someone can want cremation, inurnment, a particular cemetery, or a private service, but each choice still has its own availability and payment issue. So one yes cannot settle all four choices.
Erica, state the planning test without letting cost swallow preference.
First ask whether national cemetery burial fits the veteran's wishes. Then determine eligibility. Then separate VA-provided cemetery benefits from the household's funeral home choices and expenses.
I was wrong to make one approval answer three issues. It settles eligibility, preference, availability, and provider choices stay separate. The document reduces uncertainty, but it doesn't erase choices.
This watched view of Georgia National Cemetery puts the benefit in its real setting. The headstones and memorial flowers don't prove anyone's eligibility. They show the kind of national cemetery space VA operates. Therefore, the no-cost list comes from the National Cemetery Administration, not from the broadest meaning a listener can give the word burial.
That's the useful benefit map. It respects what VA provides without promising what the benefit doesn't contain, and it leaves room to ask separately about a burial allowance when that program may apply.
Professor Havel, thank you for keeping the fence visible.
Glad to help. Clear boundaries are a form of care.
Then the host's close is simple. Value the cemetery benefit, price the private choices separately, and don't make one approval carry a job it was never written to do.
An eligibility result nobody can find is technically organized and practically missing.
Yes, we have tested that filing system for centuries.
Now the storage promise from the opening pays off. The handoff needs four things: the pre-need notice, the DD-214 and dependent status documents behind it, the veteran's cemetery preference, and the instruction to contact the National Cemetery Scheduling Office at the time of need.
Erica, add the human instruction. Identify who is likely to make that call. A folder addressed to someone later is not a handoff.
Agreed. Name the likely caller, show them the packet, and explain that pre-need approval doesn't schedule anything by itself. At the time of need, that caller still requests the burial.
What if the address, name, or preferred cemetery changes before then?
VA says applicants can update information through the National Cemetery Scheduling Office. Keep the household copy aligned too, so survivors don't follow an abandoned preference or call with an old name and no explanation.
One scheduling office call is easier when the caller has the pre-need notice, the DD-214, and the applicant's current name in front of them.
That older caller is the test. If he has only a vague memory that VA approved something, the future office still has to reconstruct a request. If he has the notice, the file starts with an identity. And if the pre-need answer was no, the household shouldn't assume the door is sealed forever?
Correct. VA says survivors may request burial again at the time of need because law or personal circumstances may have changed. The agency makes the final determination then, so the old denial is evidence to retain, not a reason to hide the file.
Keep the unfavorable notice too. A future reviewer needs the actual reason, not a household legend about what VA supposedly said. Build the handoff now, submit VA Form 40-10007, or apply online, save the confirmation and DD-214, explain the preference, update changed facts, and schedule later.
Yeah, that's a plan with an exit. The application removes one uncertainty. The conversation removes several more, including who calls and where the evidence lives.
Here's what I'd actually do. Apply while the DD-214 and dependent status documents are reachable, store the notice beside them, and tell the likely caller where the packet is. That's the professor's verdict.
Walk away with this. Pre-need settles eligibility early, but people make it useful by preserving, explaining, and updating the file. If this gave your household a cleaner handoff, subscribe and share it with the person most likely to make that future call. The last question is yours. Who in your household knows where the pre-need notice and DD-214 are kept? The fundamentals never change. Everything else is just fashion. Take care.